guys, this is Lauren Hollows with NY Education Services, and we are coming to you with an extra video this week because, as anticipated, although a little bit earlier than anticipated, the new ASQA Fit and Proper Person form has dropped today. So I am going to be having a chat with Peter Dukas, who is an RTO lawyer. He's very well known. I'm going to be having a chat with him about this tomorrow. That interview is going to come out in just a couple of weeks. But I just wanted to kind of go through a couple of points on the new form to kind of just go through and explain its significance, its importance, and things like that. So I guess a couple of the things, like there's a lot of things on there that obviously haven't changed in relationship to just generally asking about your compliance history, particularly where you were a director, an owner, or a executive officer of an RTO. It does explain in a little bit more detail who they consider related persons. Now, I think the related persons question is very interesting, primarily because obviously it really does relate to, like, it is basically anybody who you are related to, and the new form goes into a lot more questions in relationship to specific events that those people may have gone through. Now, the definition of related party, it says ASQA may also consider any persons related to those persons who fit the definition of owners, executive officers, high managerial agents who are involved in or have previously been involved in the operations of an RTO or a cryo-cost provider, known as related persons. Related persons do not usually complete a fit and proper person declaration as relevant information is requested in this declaration. So it asks a lot of questions about your related persons, and I think it's important to keep in mind that in the context of this scenario, it's going to be related persons who have owned and operated RTOs or education institutions. So like an RTO, a cryo-cost, a higher or a higher education one. So that's particularly important. However, if you do have family members, so, you know, like my father has worked in RTOs before, it's really important to understand that their history is going to potentially like factor into this overarching sort of assessment. Now, some of the areas where it's definitely a lot more explicit, where it asks to go into a lot more detail, is in relationships of the types of offenses. So one of the things that it had in the old form was like, have you ever been found guilty of an offense? And then it said yes or no. It didn't really specify a country. So this one now says whether it was in Commonwealth, State or Territory of Australia, whether it was the law of another country. That's one part of it. But normally there was like a secondary section under that, which was basically like, well, was it just like some sort of traffic conviction? It doesn't actually allow for that anymore. So it asks you to specifically list like all of the offenses. I will be going through and completing this later on. So I guess my strategy, and I honestly am not sure if this is right. Again, this is something that I'm going to be speaking with Peter and with other lawyers about over the next couple of days. I'll basically be putting in there that it was, you know, like I've had various speeding and traffic offenses between this date and this date. And then it asks whether or not all of the fines relevant to that have been paid. And so I'll just put, basically like I've had a whole bunch of traffic tickets and yes, those are all paid, kind of a thing. That's what my approach will be. Obviously there will be others that will be literally like, no, you're going to have to go back through and you're going to have to list every individual ticket and everything like that. I look at this from the perspective of like, what is ASQA looking for? I believe that if you kind of just go, well, look, this is what it was all related to, that should be sufficient. Okay, then it goes into, are you or any related person currently involved in proceedings before a court? Again, you're going to have to document that. So whether the nature of the matter is civil or criminal. So it's really looking for, you know, I guess this then potentially leads into those sorts of issues like your AAT issues. You know, are there any like civil proceedings against you, any complaints or anything of that nature? Have you or any related person been found not to be fit and proper? That was on the last one. This does go into a little bit more detail, and it does outline relevant to funding requirements. So it's looking at a little bit more detail in relationship to you know, whether or not you have had any issues with any of your state funding contracts, which I think is a good thing. Question 9A is very interesting. Have you or any related person of your company that you or any related person were ever a director of? So have you or any related person, that's two things, or any company that you or any related person, okay, and keeping in mind, I'm still going to stick that in as a related person of who has, you know, who operated an RTO, were a director of ever been insolvent, taken steps to the benefit of the law for the relief of bankrupt or insolvent debtors, compounded with one or more creditors, made an assignment of remuneration, been under external administration, or have outstanding debts to the Commonwealth. So this is obviously an interesting one, like if you have an ATO payment plan, if you have a superannuation payment plan, is that considered a debt? So that's going to be an interesting one to tackle. Certainly that's going to be one of the questions I think that will come up. And then you've got to declare the name of the person, the nature of the event, the value of unpaid creditors, and the year the bankruptcy was discharged. So it does go into a lot more detail in relationship to that. Then it asks for your RTO and CRICOS provider history. So have you ever, do you or any related persons have a current or past association with a current or former RTO, CRICOS provider, higher education provider, other than the organization outlined in Section B of this declaration, any organization that has applied for registration with ASQA or a state registering body? So this is an interesting one, particularly where consultants or people who've worked as consultants are involved. So every time I submit a fit and proper person declaration, I generally have like a 2 or 3 page addendum that goes in with it, which basically outlines who all of my current clients are, any specific issues that have happened with those clients. So like, for example, on several cases, I've been brought in to address a non-compliance with a course, or an intent to cancel, or you know, a finding of non-compliance, and then I've worked with the client for a period of a couple of years afterwards to kind of get them fixed up and back over the line. So mine goes for quite a long ways, but obviously with a lot of RTOs, you know, you are basically going to have to now include your RTO history. Now, it doesn't say the duration to which it expects you to go into this detail. Obviously for some of us, like I've been in this game for 16 years now, I think I've probably worked with and across in excess of 40 or 50 RTOs in that time. So again, one of the questions that I would be going back to ASQA with, and that I probably will go to ASQA with, is like, what is the duration that you expect? Do you want us to go back 3 years? Do you want us to go back 5 years? Do you want us to go back 10 years? You know, I generally go back, I think I go back 5 years in the one I did most recently. I went back 5 years. So I've got like my current clients, I've got clients that I've worked with, and then I've got a separate section for compliance and regulator issues, state funding issues that I have addressed, what my role was with each of those. So I have done a lot of this basically already, but it asks you to provide the details of any current association, the person, the legal name of the RTO, the trading names, your association with the organization, and the start of your association with that organization, which is quite interesting, because I think what they are probably going to be looking for there is whether or not you started with them before, like if there's a consistent pattern of you start with them and then a year later there's a compliance issue, you know, if your role is compliance or something like that, that can be challenging. So for compliance people as well, this is going to be quite a change, you know, in relationship. Were you or any related person with an RTO, so were you or any related person associated with an RTO or CRICOS provider or higher education provider at the time of, or within 12 months prior to, a decision being made by ASQA or another vet regulator to reject an application for initial registration, cancel registration in part or full, suspend registration in part or full, renew an application to renew re-registration, determine that the provider breached a condition of registration, had a condition imposed on a registration, breached a condition imposed on a registration, or issued an infringement notice. So again, that's quite massive. It goes through the same thing for vet student loans, for fee help, issues with the Texas standards, cancel, revoke, suspend, or reject subsidy funding arrangements. So interesting, reject subsidy funding arrangements. So I guess the question there is going to be, if you applied for funding, if you were with an RTO that applied for funding, whether or not that needs to be disclosed, if it was just rejected. Been issued with an immigration minister's suspension certificate, been associated with an organization at a time when it was determined to have breached an Australian government or state and territory government funding training contract. So yes, it is focusing on the training contracts. Have you ever provided a false or misleading statement or information, not limited to the vet regulator, TEXA, TPS, state funding body, or other public agency? The reason for that particular statement, because a lot of people are going to be looking at that and going, well, yeah, but I'm just going to say no, is that they are going to be looking for circumstances where, for example, you've consistently told them one thing, but then the evidence is showing something else. Now, that's I think that one's particularly interesting because of circumstances where documents may not line up, and whether or not documents are not lining up because you don't have systems in place, or whether or not documents are not lining up because you're trying to provide a false situation. So like, you're trying to show that students are attending when they're not attending, particularly in the case of like some of these ghost colleges. So that's just a little bit of information about the changes to the RTO standards. I do anticipate it's going to take people a little bit longer. I do recommend that people provide like supporting statements, being really clear about their roles with RTOs at different periods of time, you know, things like that. As I said, like I've got I think mine's 2 or 3 pages that I generally provide a supporting statement of like who I'm currently working with, who I've recently worked with, what regulator interactions those, you know, the people that I've worked with have had. So for compliance consultants, for, you know, like if your role is compliance in an organization, especially if you're a manager, because I do believe that, you know, not owners and executives, high managerial agents. So example of high managerial agent is a consultant or employee with an ongoing role related to regulatory compliance. A consultant or employee who represents your organization at audit. So the question is going to be, I guess for me as a consultant, if I am now going to go and represent people at audit, whether or not that means I need to be listed as a HMA, it will be very interesting to see, because if that is going to be the case, we're going to see a lot less consultants in the industry, would be my guess, which is probably not a bad thing. But it's definitely going to, it does to some extent work to actually regulate consultants, which I kind of like the idea of, because I certainly feel like if you can't stand up and sit with the client, if you're going to stand up and sit with the client, then you need to be very, very clear on your role. It's going to force consultants to have really good contracts, and be very clear in like the roles that they have. So yeah, so those are some of the new examples of high managerial agents. Certainly the addition of consultant is new on that one. It also does say examples of high managerial agents where ASQA may request completion of a fit and proper person include people employed by third-party organizations who fulfill any of the roles described above on behalf of your organization, or people employed by third-party organizations who provide training and or assessment on behalf of your organization. So if you're you know, outsourcing 30% of your income to a company, that may now start to fall into HMA territory. So very, very interesting to see the changes. They're certainly going into a lot more detail. I think this is actually going to have more of an impact on the sector than people had initially anticipated. I only got this form like an hour ago, so this is all still quite new. But yeah, it's going to be really interesting. As I said, I'm going to be chatting with Peter I'm going to be chatting with him tomorrow, literally. But that interview will come out in a couple of weeks' time. Might have to catch up with a couple of other people on this as well. But yeah, that's it, guys. I hope you found this helpful. As always, like, comment, subscribe, share, all those good things. I hope you guys have a great day. Thanks a lot. This is Lauren from NOI Education Services.